Um, all right, we've got Luke, we've got David.
Today we're stepping into Judge Middleton's court, where Christopher Allen Young faces 4 separate felony cases, all rolled into what's called a global resolution. Sounds neat and tidy, right? Wrong. In less than 6 months, Young allegedly racked up a laundry list of charges: felonious assault with a jack handle, criminal destruction of property, resisting and obstructing multiple officers, including a Michigan state trooper. Oh, and let's not forget, allegedly concealing a stolen Silverado and lying to police. But that's not even the wild part. Prosecutors claim Young went from a clean record to 0 to 900 miles per hour, spiraling into chaos within weeks. We've got an attic standoff, chemicals, stolen vehicles, and enough drama to keep Netflix busy for a year. And here's the kicker. While Young's lawyer fights tooth and nail for a PR bond, prosecutors argue he's too unpredictable and a ticking time bomb. So grab your popcorn, because every turn in this hearing leads to another jaw-dropping reveal. Who's telling the truth? Who's playing the system? And why does it feel like everyone's hiding something?
We've got people. That took about 20 minutes of time we didn't have, but what are we going to do with Christopher Young?
Maybe we could put it on the record, but my understanding is we've agreed to a global offer upstairs, so it will be, they'll all be bound over.
Is Mr. Young here?
Yes, Judge, he's in custody. He also wants to be heard on bond. The court will consider it before the waivers are entered. Would you prefer to do them on the record? I do have waiver sheets, but they're unsigned.
I've got the waivers here. I'll do them on the record. That's going to take us a bit. All right, Michelle, or is he already getting him? Young, Christopher Young?
I presume so, Your Honor.
And which case are you folks here on? Okay, and which case are you on, sir? Oh, I thought you were in custody.
Mr. Young is in custody.
Oh, but you're here on that case?
Yeah.
Okay, gotcha. Are you Mr. Treestrom?
Yes, sir.
You got to deal with your circumstance. You have an open warrant for your arrest for a domestic assault earlier this month. So don't let him leave. Luke, do you have all the waivers in Young?
I do, yeah.
All right,
I have
you
all
got them.
4.
All right.
I think it'd be easier if Mr. Young just signed it next to me.
All right, that's fine. Good afternoon. Thank you for your patience. We've been in here working on some other stuff. Are you Christopher Allen Young?
Yes, I am.
Mr. Young, you have 4 cases scheduled for this afternoon. Your lawyer, Luke Knopfsinger, is here. Also, prosecuting attorney David Marvin. Their attempt is to get all 4 of these cases bound over to circuit court and try to resolve everything in what we refer to as a global resolution. That means take care of all the cases at once.
Judge Middleton drops a legal bombshell here: global resolution. For anyone unfamiliar, this is a strategy where all of Young's pending cases get bundled together into one big negotiation at the circuit court level. Here's why it matters. If accepted, every single charge, from felonious assault to resisting police, gets handled under one combined plea deal instead of being tried separately. For Young, that's both good and bad. The upside: he avoids juggling 4 trials, 4 juries, and potentially stacked sentences. The downside: one wrong move, and the entire deal collapses, meaning prosecutors can come at him full force on each individual felony. And let's not forget, with charges involving weapons, property damage, police obstruction, and a stolen vehicle, Judge Middleton is staring at a potential sentencing puzzle that could add up to decades if mishandled. So, when the judge says global resolution, it's not just paperwork, it's the legal equivalent of walking a tightrope over shark-infested waters.
File number 23889 alleges that you did assault Matthew Treestrom with a jack handle.
Did you catch that? We're not talking about minor scuffles here. This is felonious assault with a jack handle. That's a 4-year felony right out of the gate. But then it gets even messier. Another case claims Young maliciously damaged a vehicle worth thousands of dollars, while yet another alleges he assaulted 2 men using a car. Yes, you heard that right. Prosecutors say Young weaponized an entire vehicle. And just when you think you've heard enough, Here comes the stolen Chevy Silverado. The accusation: Young allegedly received or concealed the truck, then lied to police about it, adding a 2-year high court misdemeanor to the pile. So where does this leave Young? Facing a potential cocktail of felonies and misdemeanors that reads like a criminal bingo card. Would you say this sounds like a man deserving bond leniency, or someone prosecutors will fight tooth and nail to keep behind bars?
Without intending to inflict great bodily harm. That's called felonious assault. It's punishable by up to 4 years in prison and a fine of up to $2,000. File 232127. It is alleged that on or about May 1st, you maliciously or injured a car that belonged to Jamie Pierce. It's worth more than $1,000 but less than $20,000. That's a 5-year felony. And then they allege that you assaulted Andrew Chupp and Matthew Treestrom with a car, known as felonious assault, a 4-year felony. And file number 231473, which is alleged that just this month in August, that you did resist or obstruct Steve Dibble, Matt Kilburn, Eric Piper, and all from Three Rivers, and for good measure, Matt Mellinger from the Sheriff's Department and Jason Sylvester from the Michigan State Police. I don't know if I've ever had a case where someone resisted, obstructed Trooper Sylvester, but he's a big guy and he's got a real good disposition. Anyway, 5 counts of resisting or obstructing a police officer. And then the last one, file 231274, it's alleged that you did receive or conceal a stolen Chevy Silverado that belonged to Michael Gifford, and that you lied to a police officer. The RNC as a 5-year, lying to a police officer is a 2-year high court misdemeanor. You do have a right to a preliminary examination in all of these matters, and I think we got a whole bunch of witnesses here. I saw a bunch of cop cars outside, and I saw Trooper Sylvester and Officer Dibble and some other guys coming in at the end of lunch. You also have a right to waive the preliminary examination in these matters and have the matter bound over to circuit court, where they can all be negotiated as part of a total global plea. So let me read you this. I think we shared this with you, but let's do it on the record. I, Christopher Young, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. I have a right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge me with the crime. I voluntarily waive my right to a preliminary examination. Understand that I will be bound over to the circuit court on the charges in the complaint and warrant. Is that what you wish to do on each and every one of these cases?
Yes.
All right. And you've signed those.
Right.
Now, once I sign these, I lose jurisdiction, but I haven't signed anything yet. Mr. Knopfsinger wants to discuss bond here.
Yes, Judge, thank you.
Thank you.
Court takes a look at, and I assume, well, the court is always well prepared, so I assume the court has looked at Mr. Young's criminal history, which is pretty scant, coming up until the earlier part of this year. Something just fell off there.
Young's defense swings hard here. His attorney paints a sympathetic picture. Look, up until this year, my client's record was practically clean. That's a powerful narrative. Until prosecutors fire back. They argue this isn't just a man making small mistakes. It's someone who allegedly went from a clean slate to stacking felonies at lightning speed. The defense wants a PR bond, essentially letting Young walk free without paying cash up front. They lean on community ties, employment history, and the fact that he has children to support. But prosecutors shut it down, saying, "Not so fast." To them, Young's pattern of escalating violence, multiple alleged assaults, and resisting law enforcement make him a flight risk and a public safety concern. And honestly, who do you agree with here? Is this a man who deserves a second chance, or someone who's proven he'll keep pushing the limits if he walks free?
And now we have these four felony cases. We do in fact have a global resolution. And so we're waiving over with that to preserve that plea offer. Part of that plea offer too is compliance with all the terms of bond, including no contact with any and all of the complainants and the victims in the cases. And then also no other criminal activity and appearing in all further court hearings. The court considers the bonds what they are set at here, and the court has to take into consideration the severity of the charge, the public safety, and then also the defendant's record of appearance. Mr. Young very clearly says to me he did miss a hearing because he knew that he had a warrant. He realizes now, and he wants to take advantage of the plea offer that he wants to, that he would comply with the terms of bond. I know that some of the bond fee, 20,000, pretty substantial bonds. He does have strong ties to the community. He'd be living there at on River Drive. I'm not going to say the street address exactly. There in Three Rivers with a friend. He does have several children that he had contact with before his incarceration in Jackson. He was employed up until being incarcerated. He's been incarcerated now for several weeks. And I haven't scored his guidelines. I don't know what they are, but I think he's going to be on the light side in terms of PRVs, given his criminal history. He's a relatively young man. And so for those reasons, Judge, I'd ask the court to reconsider the bond, given the client is asking for a PR bond, Judge. But I ask the courts to take all that into consideration.
All right. Mr. Marvin, do you have any position on this?
I would not agree with the PR bond. There are signs that something did go awry. I think if I were to guess, I would say it was introduction of drugs and introduction of whatever company he was keeping. Because it's true that he went from 0 to, I think somebody said 900 miles an hour in a matter of weeks. And he racked all this up, but this was out of control. And 3 of these cases, we have felony assaults. And again, it could be the people he was running with, but it just was out of control. And I think a PR bond is too generous for a person with this many charges and this serious of an offense or offenses. I don't have a problem if it's relaxed a bit, but there's got to be some kind of something more than a PR.
All right. One of the complainants, Matthew Treestrom, has an open warrant for assaulting Taylor Young. So I think part of the issue is you have 2 men seeing the same woman. And that led to some of this conduct.
Judge, I think that's his sister.
His sister, all right. Then I'm not sure what this is about, but he certainly did go from 0 to 900. He was on bond on some of these when he committed the others. And what causes me the most concern is this fighting with all the on-duty police officers at the same time.
Your Honor, to be clear, that was hiding away in an attic of an apartment. It was about a 45-minute standoff that included chemicals to try to drive him out.
All right. Well,
Now this is where the case turns cinematic. Picture this. Young allegedly hides out in an attic, refusing to surrender. What follows? A 45-minute police standoff. Officers reportedly deploy chemical agents to force him out. And yes, this all unfolded in a residential complex where families lived. Here's why this detail matters. In court, resisting and obstructing isn't just about saying no to an officer. It becomes exponentially more serious when it endangers officers, civilians, and property. By escalating the situation, prosecutors argue Young crossed into territory where leniency simply isn't an option. And imagine being one of those neighbors watching chemicals fill the air while an entire building's safety hangs in the balance. So after hearing this, do you think Judge Middleton's patience is wearing thin? Or do you think Young's defense can still spin this as fear rather than outright defiance?
At the River Drive Apartments?
Yeah.
So they nuked, wasn't there?
Riverside, yeah.
Riverside townhouses?
Yes,
Whose apartment was it?
Amanda's.
Amanda.
I don't know her last name.
So they nuked the whole building so on April
Just the attic.
8th, you allegedly assaulted Mr. Treestrom with a tire iron. You got arrested on June 18th. You posted bond on June 22nd. Then you failed to appear for your pre-exam conference. So you were AWOL on that bond. Then you had the malicious destruction and 2 counts of assault, May 1st. And you got arrested on August 7th when they arrested you for failing to appear on the other case. On July 5th was the RNC stolen vehicle. You were on bond AWOL at the time that occurred. And then when they did finally arrest you on August 5th, you hid in the attic. Bond in the assault was originally $2,000, raised to $20,000 cash or surety when you failed to appear. Bond in the automobile assault and the malicious destruction is $20,000. Bond in the receiving, concealing, and lying to a police officer is $20,000 cash or surety. And in the R&O charges, it's $7,500 cash or surety. The motion's denied. This is a case of pay me now or pay me later. There's going to be a global plea offer. You were charged with a crime, posted a bond, failed to appear, committed 3 more crimes, 2 of which were assaultive, hid from the police, and you'll get credit for all the time you're serving, but I don't see the sense of letting you out just to go back into court, into jail. And you failed to appear and you committed other crimes while on bond, including assaultive offenses. So you can bring the matter up again in front of Judge Stutzman, but the motion in all cases to reduce bond is denied, and you can address it in circuit court.
Judge Middleton makes his stance crystal clear. No bond reduction. Why? Simple math. Young was already out on bond when he allegedly committed 3 more crimes, including assaults and resisting officers. That's the judicial equivalent of breaking your second chance card into pieces. Middleton's reasoning is blunt. Why would I let you out, just for you to come right back? This moment highlights a recurring courtroom reality. Judges weigh public safety above almost everything else. And with Young's alleged spiral from clean record to multiple violent charges, Middleton simply isn't buying the rehabilitation pitch. Do you agree with the judge here, or do you think Young deserves one last chance at freedom before trial?
My advice is get this case moving faster rather than slower and get to a resolution. All right, you're free to go.
That's what I'm gonna do.
All right.
So, let's go, please.
All right, Jeremy, don't go away. Matthew Thomas Treestrom has an open warrant for his arrest for assault and battery upon Taylor Young. It's alleged that Uh, On or about that date, you were in the city of Three Rivers, and the callers indicated you were punching her, throwing her down on the ground. The neighbors called the police.
Just when you think this courtroom has enough drama, in walks Taylor Young's name, and everything gets personal. One complainant, Matthew Trom, has an open warrant for allegedly assaulting Taylor Young. Prosecutors suggest overlapping relationships fueled violence, jealousy, and chaos. Young denies assaulting Taylor but stays silent on other details, likely on his lawyer's advice. Here's the kicker: multiple witnesses reportedly called in, describing a violent altercation, punching, throwing her down, and possible danger to life. Whether or not this specific charge sticks, it complicates the narrative. Suddenly, we're not just dealing with alleged crimes against strangers. There's an emotional layer, messy personal entanglements, and potential retaliation. And if you're Judge Middleton, how do you separate the personal drama from the public safety risks?
I don't want both of them back in the lockup at the same time. I want you to take him before you take him. You're going to be arrested for assaulting Taylor Young on June 27th. Who is Taylor Young to you?
I dated Taylor for a while, but I did not assault her.
All right, well, that's the
They-
allegation.
Right,
So,
the day before she was.
all right, don't say any more about it. I don't want you to jeopardize your rights. But I guess several neighbors called in. Some tweakers fighting might be killing a female. Oh boy. Anyway, it's an assault charge. And you're gonna get arrested, lodged, booked, fingerprinted, then you can post a bond, and then we'll see where we go from there. But it's an open warrant. I'm not gonna just do a court arraignment on a domestic assault. So as soon as they get him out of there, they'll take you over to jail.
Right. I'm not worried about the whole rights thing. It was the day before was Miss Taylor had called me.
All right, well,
because
I don't, again, I appreciate that, but I don't want you to get sideways and say something maybe your attorney wouldn't want you to.
I'm not, I'm very sure of it.
All right.
But she was held up by Mr. Cook, Brandon Cook, with a gun. And then we had talked to the cops that night about, her being assaulted by him.
All right.
She in turn was trying to pin, her being hands put on by him on me.
All right, well, we'll sort it out. I didn't issue the warrant, the prosecutor did. But we'll see where this goes.
So where does this leave Christopher Young? In short, bound over to circuit court with no bond reduction and a potential global plea deal hanging in the balance. If prosecutors push hard and the judge follows through, Young could be staring at years behind bars. But this case isn't just about charges and courtroom strategy. It's about escalation, personal relationships, and how quickly one life can spiral out of control. From alleged assaults with weapons to resisting officers during a chemical standoff, this hearing shows how one decision snowballs into a full-blown legal storm. And remember, nothing's decided yet. Circuit court will now shape Young's fate, plea deal, trial, or something in between. If you found this case as shocking as we did, make sure to like this video, drop your thoughts in the comments, and subscribe to Trial Truth for more jaw-dropping courtroom breakdowns.